How to fill dissolution of marriage with dependent in Florida. Filing for dissolution of marriage with dependents in Florida is a significant legal process that involves several steps. This guide will walk you through the process in detail, providing an overview of the key aspects to consider and the necessary steps to complete. Keep in mind that while this guide aims to provide general information, it's always advisable to consult with an attorney or legal expert for personalized guidance. Step 1. Understand the basics. Before you begin the dissolution of marriage process in Florida, it's essential to understand some fundamental concepts. 1. Residency requirements. At least one of the spouses must be a Florida resident for a minimum of 6 months before filing for dissolution. 2. No-fault divorce. Florida is a no-fault divorce state, which means you don't need to prove any specific fault or wrongdoing to get a divorce. The only necessary grounds are that the marriage is irretrievably broken. 3. Dependent children. If you have dependent children under the age of 18 or who are still in high school, you will need to address issues such as child custody, visitation, child support, and more. Step 2. Gather information. Collect all relevant information and documents related to your marriage, children, assets, and debts. This may include 1. Personal information, names, birth dates, and social security numbers of you, your spouse, and your dependent children. 2. Financial information, details about income, expenses, assets, and debts, including bank statements, tax returns, pay stubs, and property information. 3. Child-related information, information about custody preferences, visitation schedules, and child support calculations. Step 3. Complete the necessary forms. Florida provides several official forms that you need to complete and file with the court. Some of the essential forms for a dissolution of marriage with dependent children include 1. Petition for dissolution of marriage, Form 12.901B. 1. This is the initial document that officially starts the divorce process. You will need to provide basic information about you, your spouse, your marriage, and your dependent children. 2. Uniform Child Custody Jurisdiction and Enforcement Act, UCJA, Affidavit, Form 12.902D. This form is required to establish jurisdiction in child custody matters. It ensures that Florida is the appropriate state to handle custody and visitation matters. 3. Child Support Guidelines Worksheet, Form 12.902E. This form helps calculate child support based on Florida's child support guidelines. It takes into account both parents' incomes and the number of overnights each parent spends with the children. Step 4. Serve your spouse. After completing the necessary forms, you need to serve your spouse with a copy of the documents. This can be done through a process server, sheriff's office, or certified mail with return receipt. Step 5. Attend parenting class. If you have dependent children, Florida law requires both parents to attend a parenting class before the divorce can be finalized. The class aims to educate parents about the impact of divorce on children and how to co-parent effectively. Step 6. Negotiate and settle. You and your spouse can work together to negotiate issues such as child custody, visitation, child support, division of assets, and alimony. If you can reach an agreement, you can submit a written settlement agreement to the court. Step 7. Finalize the divorce. If you've successfully negotiated and reached an agreement, you can finalize the divorce by attending a final hearing. During this hearing, a judge will review your agreement and ensure it meets the best interests of the children. If everything is in order, the judge will issue a final judgment of dissolution of marriage. Step 8. Post-divorce matters. After the divorce is finalized, you will need to follow through with the terms of your settlement agreement. This may involve transferring property, paying child support, adhering to visitation schedules, and more. In conclusion, filing for dissolution of marriage with dependents in Florida involves gathering information, completing necessary forms, serving your spouse, negotiating settlements, and attending a final hearing. This guide provides an overview of the process, but it's important to consult with a family law attorney to ensure that you navigate the legal complexities accurately and effectively.